Thank you. We will now continue with the stage 3 and we turn to group 6 on land to which part 1 of the bill applies. I call amendment 6 in the name of Mercedes Villalba, grouped with amendments as shown in the groupings. I draw members' attention to the procedural notes on amendments in this group as set out in the groupings. And I call Mercedes Villalba to move amendment 6 and to speak to all amendments in the group. Ms Villalba.
Thank you, Deputy Presiding Officer. I'll start by moving amendment 6 in my name and by thanking Community Land Scotland and the Scottish Parliament legislation team for their support in drafting my amendments in this group. I have 4 areas for amendment in this group. Beginning with the 500 hectare threshold for large land holdings, I've lodged amendment 6, which revises the threshold down from 1,000 hectares to 500 hectares in section 1 for community engagement obligations for owners of large land holdings. Amendment 7 revises it down in section 2, and amendments 8 and 10 revise it down in section 4. A 500 hectare definition for large land holdings is something I consulted on in my proposed land ownership and public interest bill earlier in this parliamentary session. If I recall, the consultation was engaged in by a greater number of participants than that which engaged with the Scottish Government's consultation for this bill. And the proposals that I consulted on found widespread support from participants. A 500 hectare threshold is high enough that it will exclude 96% of agricultural land holdings, yet low enough as to be impactful. It's important to note that many of the land holdings which would be caught by this lower threshold will already be producing land management plans, as is good practice amongst responsible landowners, and so these amendments simply codify this. These amendments are supported by Community Land Scotland, Ramblers Scotland and others. Moving to the second area of contiguous holdings, amendments 55 to 58 remove the requirement that holdings be contiguous in order to be caught by the threshold in section 4. In relation to lotting of large land holdings, amendments 24 to 27 do the same in section 1, and amendments 47 to 50 do it in section 2. These changes would mean that a single holding is defined as the whole of the land in the ownership of one person or set of persons, and thus where the totality of land owned in Scotland is over the threshold, the measures in the bill would apply. The Scottish Government had committed to work on a stronger definition of contiguous land holdings than the 250 metres after stage 2. However, it hasn't lodged any such amendments, so I've therefore lodged these amendments which would increase the simplicity and impact of the bill while addressing the considerable negative impacts of monopoly ownership on a national scale. On the provision of lotting over 500 hectares, Amendment 53 amends the bill so that a land transfer is still caught by the lotting provisions if the land being sold is more than 500 hectares and is part of a parcel of land holdings of more than whatever the final threshold in the bill is. In the case that my other amendments to lower the threshold throughout the bill fall, Amendment 53, along with its consequentials 52 and 54, would allow that the lotting provisions are still triggered for a transfer of 500 hectares if it forms part of a landholding that is over the 100,000 hectare threshold. Finally, turning to the island threshold, monopoly ownership is especially pronounced in an island setting, which is why I consulted on introducing special provisions to protect their interests in my proposed bill. Many Scottish islands below the 1,000 hectare threshold have only one owner. Amendment 11 and its consequential Amendment 12 introduce a separate islands threshold for the provisions for Part 1 of the bill at 500 hectares and at least 25% of an island. We understand this is likely to bring in an additional 11 land holdings into the scope of the bill, many of which are owned, 11 islands into the scope of the bill, many of which are owned by one entity and which have small but notable island populations. In many island contexts, there is a small and diminishing population, so to not include islands within the bill works against the Scottish Government's stated intention to prevent island depopulation and encourage repopulation. Whereas if these amendments are agreed to, cases of poor land ownership in islands could be addressed and there could be public oversight on making island communities as sustainable as possible. Thank you.
Thank you, Ms Villalba. I now call Edward Mountain to speak to Amendment 23 and other amendments of the group. Mr Mountain.
Thank you very much, Presiding Officer. This is probably one of the most controversial sections of the Land Reform Bill. And I notice, as I've mentioned before, there is a strange alliance between Turk and Connell solicitors and Andy Whiteman when it comes to this section, as well as to other points. Now, Don MacLeod of Turk and Connell says this is junk law, especially when it comes to the definition of large landholdings. And if that's not clear, I don't know what is. Perhaps saying it's ill-conceived, badly drafted and impossible to explain is more parliamentary to using the word mince, which is what I've heard in other forums. So what does constitute a large landholding? Well, no one really knows, and I'm not sure, in fact, that the Cabinet Secretary does. What she has done when it comes to large landholdings is reduce it to a series of sizes. It is impossible sometimes to define what makes up a large landholding, whether it's one holder, a family holding, which may be held by either partner or jointly held in proportion by either partner. Could be made up of trusts with different management structures and different end goals. What we have is a bill now that's so incredibly complex that it will be a nightmare for legal professionals trying to act for a buyer-seller of landholdings of any size. What is clear, though, is it's going to result in legal challenges. And good luck with the government on that. They seem to like employing solicitors to defend their legislation and mistakes. But I don't think that this Parliament should be passing things like that. Knowing that the government will inevitably use their majority to get this bill through and to prevent a plethora of legal challenges, I'm suggesting amending this bill to increase the definition of large landholdings from 1,000 to 2,000 hectares. I have no doubt this change would reduce the threat that the government faces in terms of legal challenge, and therefore I believe they should accept it. Amendments 23 and 46 and 177 increase the definition of large landholdings, as I said, from 1,000 to 2,000 hectares for land management plans and the prohibition of transfers and lotting, respectively. Now, much of the complexity of regarding large landholdings is due to the way connected persons are defined with Amendments 137 and 181. They provide a simpler and more practical way of ascertaining whether a holding are connected. Amendment 137 refines the contiguity of the land management plan so that the holdings are considered contiguous if the land areas are managed by a single business regarding the legal status and economic organisation, commercial management and operational of that. Amendment 136 is a technical amendment consequential to 137. And Amendment 181 refines and contiguity in the same amendment as 137, but for the purposes of lotting. Amendment 180 is a technical amendment related to Amendment 181. Now, these amendments seek to define the contiguity of holdings and connected persons. I can't get that word out. I'll get it right at the end, I'm sure. The person, in the same way the Scottish Government ascertains whether or not business should be treated as a single entity for public funding. So a model already exists and is in use and is familiar to officials. Turning to the other amendments in this group, Amendment 1 from Mr Eagle on raising the threshold from 1 to 3,000 hectares would take the threshold back to where it was in stage 1 before it was amended. Now, this might be too much for some members, so my amendments 23, 46, 177 is a more reasonable, perhaps halfway house if they reject Mr Eagle's amendment. Amendment 266, in the name of Mark Ruskell, is obviously to deal with the specific problem within Mr Ruskell's constituency regarding a property adjacent to the Tay and is not relevant to the whole of Scotland. It should therefore not be in this legislation, and my comments would be the same for his amendments 267, 268, 282, 283, 287, 288 and 289. Amendments 6, 8, 9, 10, 53, 54 and 55 and 56 from Mercedes Vialba seek to increase the legal challenges the government faced by bringing more land into scope. And this was indeed rejected at stage 2 and therefore should be rejected here. Mercedes Vialba also wishes to remove the word contiguous, which has its own problems and negates the point of having a management plan where land is separated possibly by sea and therefore not linked as far as management concerned. Her other amendments, 26, 27, 47 and 48 are, in my mind, disproportionate, unworkable and burdensome and should be rejected. Some of the Cabinet Secretary's amendments in this group are rectifying junk legislation that was produced at stage 1 and as they add clarity, it's difficult not to vote for some of them. I am, however, against amendments 141, 164 and 176, which relate to tidal ground. This is obviously completely different to the interpretation of land when it comes to single farm payments. So how governments can propose this is beyond me. Therefore, I am against Amendment 178. Turning to the Cabinet Secretary's Amendment 184, 194, 198, 231, it's far too late in the legislation for this government to define what a connected person is. The fact that it is being done at stage 3 means that the Cabinet Secretary has only just realised that there is a problem with this legislation. And I'm not convinced, presiding officers, these amendments actually helped clarify the matter. I believe my amendments in the group do much more than the Cabinet Secretary's, and therefore I would ask members to vote for them. Thank you.
Thank you, Mr Mountain. I now call Tim Eagle to speak to Amendment 1 and other amendments in the group. Mr Eagle.
Thank you very much, Presiding Officer. My amendment is Amendment 1. As originally drafted, the bill proposed the land side threshold should be 3,000 hectares for land management plans, but this was reduced to just 1,000 hectares at stage 2. By setting the level at 3,000 hectares, it ensured that the obligations were on the biggest holdings, where scale issues such as ownership, control and transparency, for example, are seen as most acute. Larger land holdings often rely on scale for forestry, farming, conservation, peatland restoration, land management and more, which smaller holdings may struggle to sustain. There is a place in modern agricultural and land management for larger farms, but what might be considered small estates. There is a strong argument that if the threshold is too low, you risk destabilising holdings that are economically viable only because they have reached a certain size, and where further administrative burden may cause actually a barrier. Land holdings within that 1,000 to 3,000 hectare size may require that block size in order to access capital for infrastructure and continuity of operations, which brings with it a wider positive impact on rural communities and in many cases often support other smaller units in the area. Equally, by keeping at 3,000 hectares threshold, there is less risk of capturing what might be considered normal family farms. These are the ones that are still reeling from the family farm tax or moderately large holdings in regulations that seemed originally intended for truly large estates. As I've already argued, this legislation introduces obligations which add regulatory burden. I see a genuine risk that a lower threshold will reduce investment in land use with a potential knock-on impact to jobs, environmental activity and, most importantly, food production. Whilst I don't agree with land management plans, if they are to go ahead, it is vital that those holdings in scope are proportionate to ensure the burdens falls on those with the capacity and arguably the responsibility to handle them. Thank you.
Thank you, Mr Eagle. I now call Douglas Lumsden to speak to Amendment 265 and other amendments in the group. Mr Lumsden.
Thank you, Presiding Officer, and I'll be quite brief. I just wanted to clarify one thing. I was asked by Jackie Dunbar earlier about size of pylons. So I've done a little bit of homework in the break, and just the new pylons that are being proposed down the East Coast are between 57 and 75 metres tall, and that compares to the ones just now that are up to 45 metres tall. So I just wanted to clarify that. Amendment 265 that I have here today includes smaller areas of land that are being used for electricity infrastructure that, when added together, form a large holding. It could be that electricity transmission company owns a large number of sites with pylons, and communities should have a say on how this land is used. So this amendment would mean that a land management plan is needed and consulted on. I just wanted to say one other thing about the size. Fully support Tim Eagle's amendment to bring it back to 3,000 hectares, what was actually consulted on and what was intended on when this bill initially came out. I think going down to 500 hectares is completely wrong. I think it will bring family farms into scope. So I'm really quite confused over this war on farmers that Labour seems to have just now. So thank you. Thank you, President Officer.
Thank you, Mr Lumsden. I now call on the Cabinet Secretary to speak to Amendment 134 and other amendments in the group. Cabinet Secretary.
Thank you, Presiding Officer. Amendments 141, 164 and 176 clarify that the substantive provisions of Part 1 of the bill apply to foreshore and other land covered by water, but specifically not the seabed. There has never been a policy intention for the community engagement, pre-notification or lotting provisions to apply to the seabed, and to avoid unintended consequences, I'm therefore proposing express provisions to avoid application of those elements of of the bill to the seabed. Now, in their Stage 1 report on this bill, the NZEC committee highlighted the risks that individuals or business entities would split ownership of their land between different entities to avoid the provisions. Now, my other amendments in this group address this issue by improving the definitions at introduction, which only considered relationships between companies in the same group and those defined in legislation establishing the Register of Controlling Interest. They are technical, but they are critical amendments to ensure that the measures in this bill can't be easily avoided. They do this by making changes to the definition of composite holding, the term used in the bill to refer to holdings comprised of land which is not all owned by the same person, but is nonetheless subject to Part 1 of the bill. Holdings can form a composite holding on the basis of co-ownership or connections between co-owners. They also add to the types of connection between owners that give rise to composite holdings, so that they now include relationships requiring registration under existing people with significant control regimes. Now, I know there have been concerns raised by some stakeholders that these definitions are too complex, but unfortunately they need to be, because a lot of Scotland's land is held in ways that make understanding who owns or controls how much land far harder than it should be. This means that we need to make sure we're considering who has controlling influence over land, not just the name on the land register, and that's why I would ask members to support my amendments in this group. Now, the various amendments from Mercedes Villalba, Edward Mountain and Team Eagle on the overall thresholds encapsulate the wide range of views on setting thresholds in the bill. I did give a great deal of consideration to the thresholds prior to introduction, because I want the proposals to be applied as widely as possible, yet I don't want the provisions to have a disproportionate impact on small businesses either. Now, at Stage 1, the NZEC committee said it saw merit in aligning the land size thresholds across the bill for reasons of policy cohesion, as well as for clarity for stakeholders. And across the board, 1,000 hectare threshold was also supported by the Scottish Land Commission. I therefore brought forward amendments at Stage 2 to make this change. And I believe that the aligned thresholds create significant benefits in both their simplicity and how the measures can operate together. Now, I do have to emphasise these are brand new measures that will apply to over 55% of Scotland's land, and the bill gives government the flexibility via regulations to seek to alter the thresholds based on experience and any new evidence that may become available. Now, we'll come to the review of the provisions in Group 12, but it is right that the government should evaluate their operation to ensure that they are having the right effect. So that's why I would ask members not to support Tim Eagle's Amendments 1, Edward Mountain's Amendments 23, 46, 177, as well as Mercedes Villalba's Amendments 6, 7, 8, 9, 10, 52, 53 and 54. Because if evidence points to altering the thresholds in future, that's great, but as for now, I'm excited by the change that the proposals here will make across the country. Now, moving to non-contiguous holdings, at Stage 2, I brought forward a change reflecting advice from the Land Commission and a recommendation from the committee that public infrastructure such as roads or railways should be disregarded as a split in a land holding for the purposes of the threshold and set the distance at 250 metres. I had hoped that that might be further widened at Stage 3. I sought additional evidence, but haven't been able to fully assess the impact of increasing the distance. I'm also concerned that the further the distance between holdings, the more difficult it is to justify the provisions as a response to adverse effects of concentration of ownership on communities. Now, Mark Ruskell has brought forward an amendment to Martin Whitfield's proposed review provision to ensure that this is looked at in detail as part of a future review, and I will absolutely support that amendment. I know Mark Ruskell's proposal here to leave out the requirement that land be within 250 metres and instead refer to local authority wards is designed to bring holdings owned or connected to the owner of other land in the local area within the effects of the provisions. But while I do have a lot of sympathy for the intent behind these amendments, it could lead to holdings a considerable distance apart being treated as the same land holding. Now, the experience of operation of the measures in the bill may well provide further evidence that will allow government to take a different approach than is currently set out, but at the moment I'm not able to support these amendments. Now, Mercedes Villalba's amendments go further and allow any holdings in Scotland owned by connected persons to form a composite holding. Again, I have a lot of sympathy with that, particularly in how some landowners operate across the country, but again, I need to ensure that the provisions can be justified. And as I outlined just now, many land holdings at this scale are owned in really complex ownership patterns, and our approach at Stage 3 to maximise the scope of the bill has been focused on expanding the concept of a composite holding in the bill in order to capture as many scenarios of that controlling influence as possible. And that's why I would ask that members don't support these amendments. Now, Edward Mountain's amendments 136, 137, 180, 181 take a different approach to those I've just discussed. They're focused on the formation of single holdings under the same ownership rather than composite holdings. So that would require consideration of whether land is managed as a single business when identifying the land that is subject to the community engagement obligations and the lotting provisions. However, I am concerned that the definitions he's proposed are too vague and open to interpretation. They would also result in areas of land located anywhere in Scotland being treated as a single holding if they were in the same ownership. So, for example, it could be a farm in the Highlands and a farm in the Borders would count together towards the thresholds if considered to be run as a single business. That would represent a significant departure from the evidence base regarding the effects of concentration of ownership for communities on which Part 1 of the bill proceeds, and I can't support those amendments. In a similar way to the non-contiguous land definitions, I have real sympathy for the motivations behind Amendments 11 and 12. Islands do have particular challenges in relation to concentrated land holdings. So that's why, at introduction, when the threshold for community engagement obligations was otherwise 3,000 hectares, the bill included special provision in relation to islands. But when we lowered the threshold to 1,000 hectares, this special provision was no longer necessary. Now, I did commit to look at this further at stage 2, and I have given further thought to whether special provision is needed for islands and whether or not I'm able to support Mercedes Villalba's amendments, which seek to impose a lower threshold for inhabited islands in relation to the lotting provision in the bill, in similar terms to those that were brought forward by Ariane Burgess at stage 2. However, having reviewed the existing evidence on concentration of land holdings on islands, I can't support these amendments. A threshold of 500 hectares and 25% of an inhabited island would bring in approximately 10 additional land holdings, half of which are on islands with fewer than 10 people with the potential scope of the lotting provisions. So the costs involved in that might be disproportionate. Also, I think wouldn't be right to impose the threshold without doing that consultation with island communities and undertaking a robust island communities impact assessment too. Now, I note that Ariane Burgess has brought forward an amendment to the proposed review provision, which would ensure that the analysis evaluates the impact and effect of the measures on islands and island communities. So I very much support that amendment, but would recommend that members don't support amendments 11 and 12. And finally, I'll briefly comment on Douglas Lumsden's amendment 266 relating to electricity infrastructure. Firstly, this is a matter of interest within my constituency, so I want to make clear that I appear before the Chamber today in my capacity as a Minister of the Scottish Government. The position I am presenting reflects the collective view of the Scottish Government and concerns a matter of law and policy for which I have ministerial responsibility. Separately, and in line with the Scottish Ministerial Code, I've made my views and those of my constituents known to the responsible minister in the appropriate way. The issue under discussion today is distinct from that constituent interest, and my contributions today should therefore be understood as reflecting the Government's position, not a personal or constituency-specific stance. In saying all of that, we need to remember the purpose of the provisions that we're introducing in this bill is to tackle the concentration of land ownership and its impact on local communities, which this amendment would not address. So that's why I would ask members not to support it. Thank you.
Thank you. And I call Mark Ruskell to speak to Amendment 266 and other amendments in the group. Mr Ruskell. Thank you, Presiding Officer. Can I apologise to the Chamber for missing the very start of this debate on this grouping. I'll return back to the point I made at Group 1. This legislation really needs to challenge the imbalance of power we see in our communities that comes from monopoly land ownership. And at the very least, this bill must deliver an element of transparency. But the experience on the ground is that communities are being shut out from decision-making. Now, John Swinney will know the challenges in bringing remote and unaccountable landowners to the table to discuss their long-term plans. Discovery Land Company's plans for Taymouth Castle, Kenmore, Glenlyon and Aberfeldy is a real-world case where an aggressive developer has enormous power and is buying up the whole area: land, houses, hotels, caravan parks, shops, for a global business which is serving an exclusive clientele. And if there was ever a case where transparency through land management plans was needed, it is at Taymouth. And yet the provisions in this bill offer very little for our communities. Most of the parcels of land and assets owned by DLC fall under the threshold for a plan in the bill. They're not treated as contiguous, even though they are all part of the same business master plan. And I'd say to Edward Mountain that Perthshire is not alone. We're seeing other examples around Scotland, including Anders Povlsen buying out assets around Tongue in Sutherland, without that transparency, without that community engagement, which is so important. Now, the Scottish Government had committed to work on a stronger definition of contiguous holdings than 250 metres after Stage 2. However, no such amendment at Stage 3 has come forward from the Government, and I think that's disappointing. So my amendments build upon existing understandings of what constitutes local through using an existing statutory boundary, a council ward. This would mean that land holdings held by the same landowner which collectively exceed 1,000 hectares within the same council ward or a neighbouring council ward would fall under the provisions. They will have land management plans, prior notification and lotting provisions attached to their land holdings when they collectively reach 1,000 hectares. Now, I recognise that this amendment I'm proposing will not address the issue of aggregated land holdings held by the same, often corporate entity around the country on a national scale. And, Gresham House Limited's holdings are one example that was raised throughout the committee evidence. However, this amendment I put forward would be an important step in recognising and addressing the issue of localised land monopolies. And that is what we are seeing in Taymouth. We are seeing a localised land monopoly and a lack of transparency. Yes, I agree with the Cabinet Secretary, this bill could be amended in the future. And I know there is an amendment coming for discussion later on to look at potentially how contiguous could be, the definition of contiguous could be reviewed in the future. But I do believe that right now, with this bill, there's an opportunity to fix it. And that's why I'm bringing forward this amendment. There's an imbalance of power here. We need to address that. We should take the opportunity tonight to do it.
Thank you. Now call briefly Paul Sweeney.
Thank you, Presiding Officer, and I rise to support the amendments in the name of my colleague Ms Alba, but I also want to recognise that I have a fundamental issue with the scope of the bill. I think there has been a long-standing and unambiguous policy recognition by the Government and Parliament that land reform must encompass both the urban and rural contexts, and the current draft bill will exclude urban Scotland and other settlement types unless situated on a large landholding. So this provision will not provide any mechanisms to ensure that the public interest is considered in urban land management or urban land sales. And this is a pressing issue in urban and peri-urban areas, which are often blighted by vacant and derelict land, absentee and corporate landowners, and widespread land banking and speculation. Indeed, 67% of respondents to the bill's consultation were in favour of the inclusion of urban Scotland, and I don't think it's good enough for the Government just to put that in the too difficult to deal with pile. It's important that we grasp the opportunity of urban land reform. Yes, happy to give way.
Cabinet Secretary.
I appreciate the bill was brought forward and based on a report by the Scottish Land Commission that identified some of the most pressing issues in relation to concentration of land ownership in our rural communities. But I would hope that he would also recognise, of course, we know this bill isn't going to fix every issue overnight, but the extent of work that is ongoing elsewhere in relation to compulsory purchase orders, the consultation on compulsory sales orders, and the review that we've had in the consultation on community right to buy, because all of that, I think, will help address some of the issues that he's talking about, though I appreciate they're not in this bill as a vehicle, but there are a number of important pieces of work underway.
Paul Sweeney.
Well, I recognise that there is a lot of work underway, but there's a lot of work been underway for many years, and it feels like a glacial pace of progress in Scotland, particularly in things like compulsory sale orders, which have been on the agenda for more than a decade now, and it's just getting quite tiresome, to be honest with you, that this is continuing to not progress at the pace we need in Scotland, Presiding Officer. Glasgow, for example, where I represent, has by far the highest proportion of people living near derelict sites in Scotland, with 53% of the population living within 500 metres of derelict land. We know that living within a 5-minute walk of a derelict or vacant site can have a serious negative effect on mental health. And when the mass industrial closures and urban clearances happened in Scotland in the last half-century, people's entire neighbourhoods, where they were born, brought up, their sense of place was completely upended, and that has had a really significant social effect. So whatever we do in response to that needs to be coherent, robust and joined up, rural and urban, and it has to stitch our cities as well as our rural environments back together again. The total level of vacant and derelict land in Glasgow last year was 781 hectares, down from 834 the year before, a reduction to around 72 full-size football pitches. But the issue we need is the pace. If the current rate of annual reduction of derelict land is maintained across Glasgow, it will still take until the middle of this century to regenerate all of our current long-term industrial sites and derelict sites across Glasgow. We need to raise our ambition and to reinvent our urban centres and get people back into them. we have to figure out a way of getting some of that vacant space back into use, and residential use in particular. And the key to that is to address negligent land and property ownership in urban areas. There's around 3 million square feet of floor space in Glasgow city centre which is not in use, more than the floor space in the entire Empire State Building in New York, with 600,000 square feet of that vacant stock made up of properties which were constructed before 1919. If that were converted into residential units, it's enough for 4,500 flats. So the Scottish Government have had a commitment to urban land reform since the 2015 Act and the 2016 Act. This bill has explicitly not included that within its scope. I hope that after this election coming up in May, we can see a Parliament and Government resolved to finally reform the damaging land ownership patterns in Scottish cities, which results in significant levels of vacant and derelict sites, declining high streets and an urban housing crisis.
Thank you. And I call Ariane Burgess.
Thank you, Presiding Officer. I rise to express my support for Mercedes Villalba's Amendment 6, 7, 8, 9, 10, 11 and 12. Scottish Greens want to support these amendments. They will see the threshold of the bill reduced to 500 hectares. And research by the Scottish Land Commission suggests that 93% of land sales in Scotland are for areas below 500 hectares, with the vast majority unaffected by this change. Lowering the threshold would bring more large land holdings into scope of the requirement to produce land management plans and engage with the local community. And it would also give ministers the power to lot a larger number of holdings. The more areas of land covered by these provisions, the greater transparency we will have over how Scotland's land is used, and give more communities a voice in those decisions.
Thank you. And I remind members that Amendments 6, 23 and 1 are direct alternatives. That is, they can all be moved and decided on. The text of whichever is the last agreed to is what will appear in the bill. And with that, I call Mercedes Villalba to wind up the debate. Press to withdraw Amendment 6. Ms Villalba.
Thank you, Deputy Presiding Officer. I'd just like to begin by reminding Mr Lumsden that, as I pointed out to him at stage 2, a 500 hectare threshold would exclude 97% of agricultural holdings. So it's not accurate to say Labour is anything less than supportive of our vital food production sector. We've heard that the government won't support the islands threshold, but we haven't heard how it plans to address concentrated island ownership or how inhabited islands can be brought into the scope of pre-notification. So I will be moving Amendment 11 today. We've also heard that the government won't support the removal of the requirement for holdings to be contiguous, but we haven't heard what action this government will take to prevent asset managers like Gresham House from buying up all of Scotland. So I will be moving these amendments today. And finally, we've heard that the Scottish Government will not support lowering the threshold to 500 hectares. The Cabinet Secretary has indicated a need for evidence, but she's not outlined what the threshold for that evidence is for the government to legislate. And remembering that I consulted more widely than the Scottish Government did for this bill, so I will be pressing Amendment 6 today. Thank you.
Thank you. The question is that Amendment 6 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division, and members should cast their votes now. And the vote is now closed. The result of the vote on amendment number 6 in the name of Mercedes Villalba is yes 23, no 87. There were no abstentions. The amendment is therefore not agreed. Call amendment 23 in the name of Edward Mountain. Already debated with amendment 6. Edward Mountain to move on up. Question is amendment 23 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 23 in the name of Edward Mountain is yes 25, no 85. There were no abstentions. The amendment is therefore not agreed. Call Amendment 1 in the name of Tim Eagle, already debated with Amendment 6. Tim Eagle to move or not move?
Moved.
Question is that Amendment 1 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on amendment number 1 in the name of Tim Eagle is yes 25, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 24 in the name of Mercedes Villalba, already debated with amendment 6. Mercedes Villalba to move or not move?
Move.
Question is that amendment 24 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 24 in the name of Mercedes Villalba is yes 24, no 87. There were no abstentions. The amendment is therefore not agreed. Call Amendment 265 in the name of Douglas Lumsden, already debated with Amendment 6. Douglas Lumsden to move or not move?
Moved.
Question is Amendment 265 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on Amendment 265 in the name of Douglas Lumsden is yes 25, no 86. There were no abstentions. The amendment is therefore not agreed. I call Amendment 25 in the name of Mercedes Villalba, already debated with Amendment 6. Mercedes Villalba to move or not move?
Not move.
That is not moved. I call Amendment 134 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 134 be agreed to. Are we all agreed? That is agreed. I call Amendment 135 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally. The question is that Amendment 135 be agreed to. Are we all agreed? That is agreed. I call Amendment 26 in the name of Mercedes v Alba, already debated with Amendment 6. Mercedes v Alba to move or not move?
Not move.
That is not moved. I call Amendment 27 in the name of Mercedes v Alba, already debated with Amendment 6. And remind members that if Amendment 27 is agreed to, I cannot call Amendments 136, 266, 138, 267, 137, 267 and 139 as a result of preemption. Mercedes v Alba to move or not move?
Not move.
That is not moved. I call Amendment 136 in the name of Edward Mountain, already debated with Amendment 6. Edward Mountain to move or not move?
Moved.
Question is that Amendment 136 be agreed to. Are we all agreed? That is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Marie McNair. Can we have Ms McNair's microphone, please?
Presiding Officer, my app froze. I would have voted no.
Thank you, Ms McNair. I'll make sure that is recorded. And the result of the vote on Amendment 136 in the name of Edward Mountain is yes 24, no 87. There were no abstentions. The amendment is therefore not agreed. I call Amendment 266 in the name of Mark Ruskell, already debated with Amendment 6. Mark Ruskell to move or not move?
Moved.
The question is that Amendment 266 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 266 in the name of Mark Ruskell is yes 23, no 88. There were no abstentions. The amendment is therefore not agreed. Call Amendment 137 in the name of Edward Mountain, already debated with Amendment 6. Edward Mountain to move or not move?
Moved, Presiding.
The question is that Amendment 137 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. Vote is closed. And the result of the vote on Amendment 137 in the name of Edward Mountain is yes 25, no 86. There were no abstentions. No abstentions. The amendment is therefore not agreed. Call Amendment 138 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Question is that Amendment 138 be agreed to. Are we all agreed? Parliament is agreed. Call Amendment 267 in the name of Mark Ruskell, already debated with Amendment 6. Mark Ruskell to move or not move?
Not moved.
That is not moved. I call Amendment 139 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Question is that Amendment 139 be agreed to. Are we all agreed? That is agreed. Call Amendment 140 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Question is that Amendment 140 be agreed to. Are we all agreed? That is agreed. Call Amendment 141 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Question is that Amendment 141 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on Amendment 141 in the name of Marie Goujon is yes 86, no 24. There were no abstentions. The amendment is therefore agreed. Call Amendment 268 in the name of Mark Ruskell, already debated with Amendment 6. Mark Ruskell to move or not move?
Not moved.
That is not moved. I call Amendment 269 in the name of Michael Matheson, already debated with Amendment 116. Michael Matheson to move or not move? Question is that Amendment 269 be agreed to. Are we all agreed? That is agreed. It takes us to Group 7, Enforcement of Obligations. I call Amendment 142 in the name of Rhoda Grant, group with amendments as shown in the groupings. Point out that Amendments 37 and 148 are direct alternatives. That is that they can both be moved and decided on. The text of whichever is the last agreed to is what will appear in the bill. Rhoda Grant to move Amendment 142 and speak to all amendments in the group. Ms Grant.
Thank you, Presiding Officer. I move Amendment 142. Amendment 142 adds a community body as defined by the Community Empowerment Scotland Act 2015 as a body that can report a breach of obligations under Section 44E of the bill. This bill seeks to promote the rights of communities, and this amendment allows communities to report breaches. The bill already empowers community councils and the like to do this, and therefore this amendment simply recognises groups defined by the Community Empowerment Scotland Act in the same way. Amendment 270 empowers grazing committees in the same way to report breaches as does Amendment 144. I will not be moving Amendment 144, but pressing instead Amendment 270, which was drafted with the aid of government, which I hope indicates their support for that amendment, and thank them for their assistance with that. The amendments from Tim Eagle and Edward Mountain in this group try and make it more difficult to report breaches and also lower the penalties for said breaches, and therefore we cannot support them.
Thank you. I call the Cabinet Secretary to speak to Amendment 143 and the other amendments in the group. Cabinet Secretary.
My amendment in this Group 143 is a simple drafting correction with no legal effect, so I hope it can be supported by all parties because it provides consistency with wording elsewhere in Section 44E. Now, turning to non-government amendments, I thank Rhoda Grant for speaking to her amendments in this group. Amendment 270 is preferable to 144 because it will make sure that both grazing committees and grazing constables are able to report breaches. Amendment 142 would add two further types of bodies, community-controlled bodies and development trusts. Now, there is an issue with this amendment in that it applies to community bodies generally, not just the two examples mentioned in the amendment, but it doesn't define the term. So this would create uncertainty regarding which bodies are able to report a breach. Now, bodies that have registered an interest under Part 2 Community Right to Buy or are eligible to register an interest are already able to report a breach, as are community councils. So in many cases that would cover community-controlled bodies within the vicinity of the landholding. But if through experience we see that further expansion to the list are needed, then there are the powers in the bill that would enable that to be done. So for these reasons, I support Rhoda Grant's Amendment 270, but not the other amendments in this group. Turning to the Conservative amendments, Edward Mountain's amendments 145, 35, 146 and 26 introduce unnecessary complexity and they remove the ability of the LCC to adapt processes to the circumstances of an investigation. His amendments 31, 34 and 36 attempt to establish timescales that would apply prior to the point that the LCC had made a decision to investigate a breach. Now, there isn't an obvious benefit to that, and it's not clear how compliance with these timescales could be clearly established, which is why I can't support those amendments. Now, the NZEC committee highlighted concerns in their Stage 1 report that the fine levels at introduction would be an insufficient deterrent for non-compliance. Bob Doris's amendments at Stage 2 made sure that it isn't cheaper for owners of the largest landholdings, some of which are over 17,000 hectares in size, to just pay a fine rather than comply with the obligations that we have in the bill. Now, amendments 37, 140 and 150 would reverse that improvement and should not be supported. Now, turning to Tim Eagle's amendments 271 to 274, I'd first like to highlight that the maximum penalty amount will not be the first stop in the majority of cases, and it is there to provide a deterrent to repeated or recurring breaches of the obligations where the landowner demonstrates that no action has been taken to remedy the breach. And the bill does already contain a number of safeguards to ensure that approach. So for breaches of the community engagement obligations, the Land and Communities Commissioner can only impose a fine after the person who's committed that breach has been given the opportunity to rectify it, except where this isn't appropriate, taking into account if there has been previous non-compliance. And for fines in relation to enforcement notices, these can only be imposed where there has been a previous fine, the breach still has not been remedied, and the person who committed the breach has been provided a further opportunity to resolve the issue. So these safeguards already ensure that the fines are only imposed as a last resort and that previous non-compliance is considered. In addition, I am concerned that there are drafting issues with some of Tim Eagle's amendments that make their effect unclear. They might actually block maximum fine levels being imposed even where a landowner had breached other obligations multiple times previously, because they seem to only relate to a previous breach of the exact same obligation being considered. So it's for those reasons that I can't support his amendments. Now, the rest of Edward Mountain's amendments in this group should also be rejected. 28, 32, 29, 30 and 33 would place limits on when the Land and Communities Commissioner could investigate a breach, raising the risk that issues impacting communities go unaddressed. Like many others in this group, Amendment 38 would impose needless requirements on ministers for little benefit. Amendment 147 would again weaken an improvement made at Stage 2, which was based on a recommendation from the NZEC Committee Stage 1 report. The ability for the LCC to redact identifying information from breach reports before they're shared with the landowner is a really important protection to ensure that people feel able to report a breach without the fear of repercussions from the landowner that could then impact their housing, employment or access to land. I see no good reason for this to be limited only to cases where the information would impact a commercial business. And turning finally to Amendment 149, I accept that there might be merit in having guidance on enforcement, and this is something that the LCC will be able to consider an issue without an amendment to the bill. I may have been minded to give this amendment further consideration if it didn't contain a completely nonsensical requirement for this enforcement to be published within 6 months of royal assent of this bill. So I look forward to hearing from Edward Mountain as to how the Land and Communities Commissioner is expected to produce guidance on enforcement of obligations that won't yet even be set out in regulations. What's more, the Land and Communities Commissioner is a new role that will need to be hired following royal assent. So if Edward Mountain is to get his way with his other Stage 3 amendments, which block virtually everyone with relevant experience from this role, then this might be a very long application process. So that's why I would urge members to reject this unworkable amendment. Thank you.
Thank you. I call Edward Mountain to speak to Amendment 28 and other amendments in the group. Mr Mountain.
Thank you, Presiding Officer. And it looks like we're going down a well-trodden path, and every single one of my amendments are not worth considering. I have 15. Well, you know, I never like being told by somebody that they're perfect, and that's what we're getting here, and that my amendments aren't worthy of consideration. And I find that slightly disrespectful in relation to this. My amendments in this group, of which there are 15, are to ensure that the Land and Communities Commissioner is mobilised to investigate breaches where appropriate. Sorry, did you want to make an intervention?
Cabinet Secretary, briefly.
Sorry, I didn't see. Yes, I would take an intervention.
Cabinet Secretary.
I want to thank Edward Mountain for taking the intervention, because I really have to pull him up on the comments that he's made in relation to not accepting his amendments. Now, he touched on earlier about engagement with the Scottish Government, which we did have. My door has always been open, as it has been to any member, to discuss any amendments to the legislation. However, the member did not want to disclose all his amendments to me or discuss other areas that he wanted to go through. I would have been perfectly open to discussing that and seeing if there were a way that we could make amendments work.
Mr Mountain, I'll give you some of that time back.
Thank you. I'm not sure that was a question. I think that was a statement. And I'm not sure, actually, when I saw the Cabinet Secretary, she disclosed all her amendments to me. But I'm not going to play a tit-for-tat business. I'm going to talk about how to resolve this. And Cabinet Secretary, what we're talking about here is that I want the Land and Communities Commission mobilised to investigate breaches where evidence and to tidy up the timescales which are missing within the bill's current drafting and reduce the potential fine for landowners for breaching the community engagements down to 20,000 from 40,000, which seems to be an arbitrary figure that was agreed at stage 2. The Commissioner's investigation of a breach is covered by Amendments 28, 29, 30 and 32 and provide that the Land and Communities Commissioner must only investigate a report of an alleged breach if satisfied of certain conditions, and that the report must have been submitted by a person permitted to do so. And the Commissioner must not investigate if they are not satisfied there is sufficient evidence within the report or that it is based on the same facts of a previous report, regardless who submitted it. Amendment 33 is a technical amendment. It makes sense to me that any decision to investigate an alleged breach should be based on the facts of the breach and not who reports it. It would be an unacceptable waste of resources and an unnecessary burden on the landowner for the Commissioner to be required to investigate the same breach or proposed breach again and again and again if reported by different people, even if it was without foundation. Amendment 47 means that the Commissioner may provide the report in a redacted form if, and I repeat, Cabinet Secretary, only if the identification of the individual through personal information contained within the report could adversely affect a commercial business. I have no problems with people standing up and saying there is a fault, providing they're not held to account if it affects their business, but they shouldn't be frightened of doing so. Timescales are covered by Amendments 31, 34, 35, 36, 38, 145, 146. Amendment 34 enforces a maximum 28-day time limit on the reporter's provision of additional information regarding the alleged breach. That just means it doesn't go on forever and ever and ever. Amendment 34 means that the Commissioner must send a copy of the report and a request a response to the person alleged to have committed the breach within 10 to 28 days of deciding to investigate the breach. That seems perfectly sensible to me. And Amendment 35 enforces a maximum period of 6 weeks for the person alleged to have committed the breach to respond to the report therein. Amendment 36 imposes a maximum timescale of 28 days on the Commissioner, during which they must send a copy of the report and request a response to the alleged person alleged to have committed the breach. Amendment 145 clarifies that the Commissioner must send a copy of the report and ask for their response at the same time, giving notice to the person in writing who has submitted the report they have decided to investigate the breach. That's keeping everyone informed. Amendment 146 clarifies that the Commissioner's request for a response to the breach from the alleged person must be reasonable and not exceed 6 weeks. Amendment 38 provides that the period with the steps must be taken to remedy a breach of the management plan must be reasonable in all circumstances. Can't understand why we don't like the word reasonable. Amendment 30... I will give...
Russell Finlay, briefly.
Thank you. I just heard the Cabinet Secretary talk about unworkable amendments, and I wondered if the member agreed with me that hearing this government make accusations about unworkable amendments is somewhat ironic, given their track record of disastrous and unworkable legislation.
Edward Mountain.
Well, do you know, I think there's definitely something within here. What we're trying to do is, on this side of the chamber, is try and help the government prevent themselves getting themselves in a pickle. And we tried to do that when it came to the deposit return scheme. So let's turn to Amendment 37, which is reduce the fine of a breach from the management plan from £40,000 to £20,000. And Amendment 149 obliges the Commissioner to publish guidance on the scale of the enforcement of the fines within the 6 months of the bill gaining royal assent. Well, look, you know, we're going to talk about who can be a commissioner. I mean, at the moment, the government seems to discriminate against landowners, but we'll come to that in due course. No, well, you can make all sorts of noises. Wait till we get to the amendment, and then let's see where you go on that. And I acknowledge that the timescale may be tight, but with significant fines as the ones that are being suggested, there should be an absolute clarity about when and on what scale those fines would be enforced. If I have time.
The member is bringing his remarks to a conclusion.
Okay, I'll bring my, my remarks to a close, Presiding Officer. Turning to the other amendments, I do not support Amendment 142 in the name of Rhoda Grant because the definition of community body is so wide. I also cannot support Amendments 270 and 144. All of Tim Eagle's amendments in this group, to me, appear sensible, and I will obviously support his Amendment 148. But if it falls, mine is, of course, the appropriate halfway house and should therefore attract the attention of the government.
Thank you, Mr Mine. I call Tim Eagle to speak to Amendment 148 and other amendments in the group. Mr Eagle.
Thank you, Presiding Officer. Following amendments at stage 2, the bill would see a fine imposed on a landowner who breaches a land management plan obligation of up to £40,000. A fine of up to this amount could see a farmer or landowner penalised more than someone who has committed a serious environmental crime. And whilst the government seemed content on imposing a £40,000 fine on Scotland's food producers for an administrative failing, they have been criticised themselves for failing to provide any plan for the land they acquired on the Glenprosen estate, despite acquiring it 3 years ago. £40,000 is widely disproportionate and risks burdening farmers and landowners with unfair, disproportionate, heavy penalties. Our amendment proposes to reduce this to £5,000 as originally drafted. Happy to give way to Bob Doris.
Briefly, Bob Doris.
Tim Eagle for giving way. Mr Mountain said that £40,000 is an arbitrary figure. Mr Mountain is proposing £20,000, which I suppose is an arbitrary figure. £5,000 is a figure that the Conservatives believes is much less than it would cost to actually produce a land management plan according to Conservatives. How did you arrive at £5,000 as a figure, Mr Eagle?
Through the chair, Mr Doris. Tim Eagle.
£5,000 was the figure that the government minister and workers in the background thought was reasonable at stage 1. And I think they're right. That is a reasonable figure at stage 1. And I think we should go back to that. That increase to £40,000 is just far too disproportionate. As amended at stage 2, in terms of Amendment 150, as amended at stage 2, the bill could now see a further fine imposed on a landowner who does not remedy a breach in obligations under land management plans of up to £40,000. Once again, our Amendment 150 proposes to reduce this to £5,000 as originally drafted, and my amendments 273 and 274 following the same reasoning as 271 and 272, except in the context of where it is found a breach has not been remedied. Both amendments would seek to ensure that the total £40,000 penalty currently laid out in the bill is imposed only on repeat offences. This would create clarity in the legislation as to when such a sizable penalty is going to be enforced. And before I stop, can I just pick up on a comment that the Cabinet Secretary made around drafting issues? I don't quite know what the Cabinet Secretary is getting at with that. I put forward what I thought was reasonable to the legislation team, and they come back with the drafts to me. So I think if we've accepted it into the stage 3, then surely that's a reasonable amendment to put forward. So I'm not sure I get what the Cabinet Secretary is attacking me for with that, but maybe she's trying to defend what is an absolutely disgraceful amount of money to being imposing on landowners. Thank you, Presiding Officer.
Thank you. And I call on Rhoda Grant to wind up. Press or withdraw Amendment 142. Ms Grant.
Thank you, Presiding Officer. I have nothing really more to add other than to press 142.
The key question is that Amendment 142 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is closed. The result of the vote on Amendment 142 in the name of Rhoda Grant is yes 27, no 80. There were no abstentions. The amendment is therefore not agreed. Call Amendment 143 in the name of the Cabinet Secretary. Already debated with Amendment 142. Cabinet Secretary to move on formally.
Moved.
Question is that Amendment 143 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 144 in the name of Rhoda Grant. Already debated with Amendment 142. Rhoda Grant to move or not moved?
Not moved.
That is not moved. I call Amendment 270 in the name of Rhoda Grant. Already debated with Amendment 142. Rhoda Grant to move or not move?
Moved.
Question is that Amendment 270 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. Votes closed. And the result of the vote on Amendment 270 in the name of Rhoda Grant is yes 84, no 25. There were no abstentions. The amendment is therefore agreed. Call Amendment 28 in the name of Edward Mountain. Already debated with Amendment 142. Edward Mountain to move or not move?
Moved.
Question is Amendment 28 be agreed to. Are we all agreed? We are not agreed. There will be a division and members should cast their votes now. And the vote is closed. Point of order, Nicola Sturgeon.
I couldn't connect. I would have voted no.
Thank you, Ms Sturgeon. I'll make sure that is recorded. The result of the vote on Amendment 28 in the name of Edward Mountain is yes 25, no 86. There were no abstentions. The amendment is therefore not agreed. I call Amendment 29 in the name of Edward Mountain. Already debated with Amendment 142. Edward Mountain to move or not move? The question is that Amendment 29 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is closed. And the result of the vote on Amendment 29 in the name of Edward Mountain is yes 42, no 86. There were no abstentions. The amendment is therefore not agreed. I call Amendment 30 in the name of Edward Mountain. Already debated with Amendment 142. Edward Mountain to move or not move?
Moved.
Question is that Amendment 30 be agreed to. Are we all agreed? No. Parliament's not agreed. There will be a division and members should cast their votes now. Vote is closed. Point of order, John Mason.
On Amendment 29, I thought I heard you saying 42 for and 86 against, which I don't think was correct.
Let me double check. Thank you, Mr Mason. The result of the vote on Amendment 29 in the name of Edward Mountain is yes 42, no 68 and no abstentions. The amendment is still not agreed. Thank you, Mr Mason. The result of the vote on Amendment 30 in the name of Edward Mountain is yes 30, no 81. There were no abstentions. That amendment is not agreed. Call Amendment 31 in the name of Edward Mountain. Already debated with Amendment 142. Edward Mountain to move or not move?
Moved, Presiding
Is Amendment 31 be agreed to? Are we all agreed? Parliament's not agreed. There will be a division. The members should cast their votes now. I've been informed that Parliament TV is not functioning at the moment, so I'm going to briefly suspend until we find out what is wrong with that.